okay for the courtroom deputy to go ahead and open court?
Thank you.
All right, thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everyone.
Morning.
Good morning.
Ms. Atassi, you may proceed.
May it please the court. Sahara Tassi, court-appointed counsel for petitioner Trokan Dian. I'd like to reserve 5 minutes for rebuttal.
Yes.
This case turns on a simple principle. The agency cannot create evidentiary gaps and then rely on those same gaps to deny relief. Particularly where a non-citizen is detained and unrepresented, an immigration judge has an affirmative duty to develop the record and ensure a meaningful opportunity to be heard. That duty was not met here. Mr. Dian was a detained pro se 22-year-old when he was ordered removed to Liberia, a country he has never been to and where he faces grave risk of persecution, without ever having a meaningful chance at a fair hearing. The government concedes critical notice defects in its proceedings, and the IJ compounded those defects by excluding Mr. Dian's evidence, failing to explain what he needed to prove or how to prove it, and failing to probe or elicit testimony about facts central to his claim. Despite those failures, and after expressly finding Mr. Dian credible, the IJ denied every form of relief for lack of corroboration, based on the very deficiencies the agency itself created. That is precisely what the duty to develop the record forbids. The IJ then deepened those errors by misapplying key legal standards, including improperly applying the per se particularly serious crime bar to withholding relief, and the heightened hardship standard to his waiver of inadmissibility. The stakes for Mr. Dian, who has been in the United States since age 2, could not be higher. Remand is required so the agency can apply the correct standards on a fully developed record. Your Honors, unless you have questions, I'll begin with the statutory duty to develop the record argument, which we believe is the cleanest basis for remand here.
Well, but how is it also not totally unexhausted?
Your Honor, in the BIA brief, the overarching theme is that Mr. Dian did not understand what was expected of him, and the IJ didn't help him. In Atom King, this court advised how it looks to substance over form, and that when a claim is raised in essence, that is enough, and that magic words weren't required. Mr. Dian at JA 328 explains how there were numerous indicators that he didn't understand what was expected of him, concerning the lack of evidence submitted in support of his relief applications, incomplete forms, lack of country conditions, witness affidavits, witness testimony. He also states in the brief, it seems clear that either he did not understand his obligations to corroborate his applications or was unable to do so, and that the IJ denied the relief based on that failure to corroborate. So exhaustion doesn't require precise legal labeling under this court's precedent, and in Atom King in footnote 6, the court explains that any ambiguity.
How isn't the BIA? I'm looking at it, and I've asked people to look again at. It seems pretty clear to me that in the BIA brief, what he's complaining about is the letters.
Your Honor, he raises the letters, but it is about the process.
And it's not the IJ's responsibility to submit letters for him, so I don't know how that falls within the duty to develop the record.
Your Honor, he was unable to submit his letters. The letters weren't accepted because he did not have proper notice.
Well, then let me take you to that. I do not understand how anybody could hear what the IJ said and think that you can submit letters in October. I agree that the transcript is unclear if it's September 6th or September 26th. And so if the argument was like he submitted them on the 25th and they got bounced for being late, I think you'd have a great argument. I don't understand how there was any legitimate confusion that it wasn't October.
Your Honor, I think there's two parts to this. First of all, he is pro se, he's detained. He has, in the IJ, in the transcript segment that you're referencing, the IJ does affirm kind of the 3 dates. And then he says you can have more time. He says you can have more time if you need it. Moreover, there's not a written notice that comes afterwards. The only notice in the record is for a hearing that ended up not happening on that date. It's not, Mr. Dion tried to comply as much as he could. He did not even have the address of where to submit these letters to, and the other evidence to. He submitted it to the Baltimore Immigration Court. He says sometime in early October. That is one of the dates that the IJ did seem to confirm in the proceeding. So there wasn't enough notice for
Confirm for the proceeding, not confirm for when you submit letters. I don't understand anything in the transcript that suggests letters can be submitted in October.
Your Honor, he does seem to there are 3 dates that he raises, and the IJ does confirm all of them, and then says it will give you more time. Moreover, even had he sent them by the later date, September 26th, he would have sent them to the Baltimore Immigration Court, the only court whose address that he has. So it really isn't the proper notice for someone who's detained, someone who's pro se. It's a confusing transcript to be a conversation.
Can I ask you just another question about these letters? So the government says this is harmless because they ended up, we ended up basically getting the information. And I understand your argument in the reply brief to be the letters the government is pointing to are not the right letters that we're talking about. Is that a factual statement of what your argument is?
That's correct.
So then am I correct that the letters in question are literally nowhere in the administrative record at this point?
That's correct. The letters were
And your
not
client, that which means because your client didn't submit them to the BIA either? They weren't submitted to the IJ, which could perhaps be explained by your client was not told when he needed to do it, but they weren't submitted to the BIA either. So we're supposed to grant a PFR based on representations about what letters that the court literally can't see would have been prejudicial?
Your Honor, the letters were not submitted with the BIA. Mr. Dion did not have them after he sent them to the Baltimore Immigration Court, is my understanding. But the problem is that these letters did not make it into the record. They never made it into the record. It was lettered.
Conduct a prejudice analysis of letters that the party that's urging error has never made part of the record, because how can I possibly assess that they're prejudicial if I don't know what they say?
Your Honor, I think part of the problem, and this goes towards the duty to develop the record, is we don't have, the record doesn't exist. And it's not Mr. Dion's fault here. The IJ had a duty to develop that record. The letters didn't make it in. His other corroborating evidence didn't make it in. He tried to comply as best as he could to get that evidence into the record. And that didn't happen.
Counsel, let me ask you this, because I think, and just in following up to Judge Hyden's question, I'm not quite sure how we are to assess the issue of prejudice here if we don't have the evidence in the record. I mean, what if the written statements don't add anything else? I'm just a little concerned about how this court is supposed to be able to assess any prejudice with the exclusion of the evidence.
Right. So if the court does find that there was a duty, the IJ failed the duty to develop the record, the prejudice, that failure would be presumptively prejudicial, as this court has explained, that a non-citizen can't produce a record that doesn't exist. If the court were to analyze this as a due process failure, we would have to show, a likelihood, a reasonable probability of a different outcome. We don't have the letters. We know that Mr. Dion sought to submit letters, sought to submit country condition reports and other documents, but he never had proper notice to submit those letters. The outcome could have been different if Mr. Dion had the proper notice, both of the hearing date, of where to mail these documents, of how to have witnesses support his claim. There's several notice issues here, and the letters are just one piece of that.
So is it your position that we can say there's this due process violation just based on the exclusion of the letters?
It's not just the exclusion of the letters, Your Honor. So due process requires notice and an opportunity to be heard. Here, he had no notice of his hearing date. He thought his hearing date was going to be on a different day. He had no written notice. He's in his jail cell. He's taken into, to a different room to start his hearing that day. And then halfway through the hearing, he finds out that the evidence that he thought that he had mailed, that he had thought the BIA would have, or that the IJ would have, was not there, and that the IJ would not be reviewing it. He also finds out partway, and he had mailed those letters to the only address he had ever been given by the court. He had never been given the Philadelphia Immigration Court's address. He had never been given a written notice that his case had been transferred. So he mailed these letters and his other evidence to the only court he had an address for. And then also partway through the hearing, he finds out that he could have had witnesses. He didn't understand he could have had witnesses to support his claims. So there's, had he been aware of all of these things, the outcome, there is a substantial likelihood, a reasonable probability of a different outcome in this case. So that is the due process violation here that we see.
Well, Mr. Tassi,
Can I ask you something?
go ahead, Judge Hyden, go ahead.
I was going to switch topics, Judge Gregory. Go ahead.
Yeah, well, yeah, okay, this is on this one. Ms. Tassi, I think your argument is that really the due process is not based on the quantum, the weight of what might have been, but it's the fact that he did not have a chance to have those presented. It's like a person who's charged with a criminal case with just all kinds of evidence against them, but if they weren't told or weren't there available to hear it, no matter what their defense was to it, how meager it is or non-existent, the due process violation is the fact that they were not there to be considered one way or the other. And for example, here, did they ever, the Baltimore office ever say, send these things to Philadelphia?
So the IJ says in that kind of confusing back and forth, send them to me, but now at the Philadelphia Immigration Court. He doesn't, which is unclear because up to that point he had been, his IJ before the Baltimore Immigration Court. He's never given the Philadelphia court address. And Judge Gregory, I agree with you. This is about whether Mr. Dion was able to submit his evidence at all and whether he had a fair opportunity to present his case. It's not about specifically whether the letters were sent to the right place or made it in on time.
Right, because he was detained the whole time, was he not?
Correct. He was detained the whole time.
So can I ask you a question? Can I ask you a question about the inadmissibility waiver? Where I'm just having a really challenging time because, so at a high level of generality, right, there's a standard that you have to meet in order to be eligible for it all. But then as I read the statute and as I read Gene, at the end of that process, the executive branch can also just say, yeah, you meet all of the requirements, but it's still going to be a no. Why? Because I decided it's going to be a no. Is that, broadly speaking, your understanding of how this statute works?
Correct, but the court does retain jurisdiction to review.
I know that's just a framing question. Is that your understanding how the statute works?
It is, but that is balanced against a
Okay, so let me ask you that. Let me ask you. That was just the setup for the question I wanted to ask you. What if, I know this is not what the IJ said here, but what if what the IJ said here was something to the effect of, the IJ goes through the heightened waiver stuff and he concludes that your client fails that standard. The IJ says all that. But then what the IJ says after it is this. Let's assume I was wrong about violent or dangerous, that it should have been the regular waiver standard. I would still think you fail under the regular waiver standard, so no. Would we have to affirm in that situation as harmless error?
Sorry, if he was found to be not violent or dangerous and denied.
No, the IJ first finds that he is and concludes that he's ineligible because he's violent or dangerous. But then the IJ, in the way that district judges sometimes say in federal sentencing, let's assume for the sake of argument that I'm totally wrong about everything I just said. Let's assume for the sake of argument that I don't think he's violent or dangerous. So I'm going to also, in the alternative, apply the regular standard. He loses. Would that be harmless error in that situation? Because the IJ is essentially given two completely independent justifications for the same conclusion.
Your Honor, I think part of it though is it's after a finding of extraordinary. You have to wait to extraordinary hardship though. So
why? Why? If at the end of the day the IJ can just say, who cares? Like that's what I sort of read matter of Gene. I mean, I guess I read matter of Gene as saying two things. One, IJs, you're all way too quick to do this. That needs to stop. And the second thing that matter of Gene pointedly says is you could literally you could meet every single requirement and the Attorney General might just decide the answer is still no. Right? I mean, that's correct under the statute, isn't it?
I think IJs are allowed a broad range of discretion. I think here the IJ misapplied the legal standard and raised.
But then the IJ also said, but in the alternative, I do the same thing for another reason. So why isn't that harmless error?
Because he weighs that same crime, that same offense again in considering the positive and negative equities. So that legal
But why
error.
isn't he allowed to do that, even under the regular standard?
Because he framed it as a violent or dangerous offense. So he's weighing the violent or dangerous offense and another offense against his positive equities as well. Thank you.
Thank you, Mr. Tyson. Mr. Alexander?
May it please the court. There are several issues here, and we can take them one at a time.
Yeah, okay, let's start with the fact that this IJ orally told somebody his case had been transferred and he never got a written down. What the heck is that?
Well, Your Honor, that's not the best way to conduct business.
Is that a legally permissible way to conduct business?
Yes.
To orally tell someone who is detained in pro se, this is going to be the only notice that we've transferred your case, is me telling you orally?
So the significance of that is where to send the documents, right? That's the reason that it matters where the hearing is going to
Don't
be
you think
conducted.
it's pretty important to tell a pro se incarcerated individual as clearly as we possibly can where he's going to send things, and that maybe saying it to him on a Zoom call while he's in detention is a pretty lousy way of giving anybody, much less a pro se incarcerated person, notice of something is important to? Where do you need to send the evidence that you hope to use to prevent your removal from the United States?
Well, the IJ said it quite clearly. It was quite clear in the transcript, send the materials to Philadelphia. Now, the interesting part of that exchange is that Mr. Dion was hung up on the due date and not on the where. So it was
Yeah, but don't you think that if the IJ told him to send it to Philadelphia, he should, at some point, the IJ should have said, where in Philadelphia? I mean, and I understand that the IJ is not there to give legal advice, but I think here that he realizes it's a pro se non-citizen. I mean, to me, it seems as it would be appropriate to tell him where to send it.
That would be better. No question, it would be better practice, but he gave him a clear instruction.
Well, it wasn't clear because he didn't tell him where to send it. He gave him an instruction. I don't know
Yes.
if you can say it was clear, because if he doesn't tell him where to send it, then I don't know if that's a clear instruction.
Well, I understand your point, Your Honor. And again, this is not necessarily the best way to do business, but it is an acceptable way to do business. The instruction was send it to Philadelphia, and Mr. Dion never asked the question, well, where should I send it to? Again, he was hung up on the when and not the where.
But Mr. Alexander, all the previous correspondence was contacts with Baltimore office, correct?
Correct.
And that's the office he would have known the address to and had an understanding and a relationship in this sense of the litigation, if you will, or what the question before the agency. That was all Baltimore, and you just say send it to Philadelphia, and period. Where in Philadelphia? Send it down South Broad Street, or send it to West Philly, or where? That's you say it's not the best practice, but is that any kind of way to deal with a serious matter like that, being deported from the United States? And we know how great this country is, and how it has, and the people have come in here and helped make it great and continue to do that. And you say that's enough, because that just by saying, well, that's a better way it could have been done. But is that the right way to do it when you're talking about due process? This is a legal situation here. Can you answer that? Because you seem to be, kind of, I won't say cavalier, but he said, well, it could have been done better, but good enough for government work? Or what are you talking about?
Well, Your Honor, the transcript is what it is. But,
Yeah, it is, and it
and
just
so,
seems to be deficient, and it's deficient from a due process point, isn't it?
well, the other point is, on all of these due process arguments is prejudice. So where is the prejudice? Mr. Dion sent the documents well later than they needed to be sent. So it didn't matter where he sent them to, they were late. Secondly, as the court was discussing earlier, we don't know what was in that packet. So if we don't know what was in there, then we have no idea whether it's prejudicial to Mr. Dion or not that the material was never received. I think it's also an interesting point that there's discussion of, well, should the materials have been admitted? Should the immigration judge in his discretion admitted the materials? Well, there was nothing to admit. The materials they're not in the record. We don't know what they were. We don't know where they went. So again, where's the prejudice?
Or did you look for the Baltimore office and call them up and say, I mean, not you personally, I mean, but the agency say, well, did you get any papers from someone by that name and at all?
You know, that's not in the record. I can't answer that.
And so we had to assume that that wasn't done.
Well, we could assume it was done. I don't think it
No,
would
how can we
matter.
assume it was done? No, we have to assume that it wasn't done, because if it was done, then if they found nothing, they would say, well, here in the record said there's nothing based on response from Baltimore. They never received any papers. So everything you say is against him, but nothing. The agency has no responsibility. Well, we have to assume that it was never sent. I don't see how you get that conclusion.
Well, again, I'm not sure that it matters whether Baltimore got it or not, because the hearing was conducted on October 12th. The materials were not available on October 12th, and the judgment was rendered. So,
And that's a hearing that may have been so tainted with a lack of due process that it, in a sense, from a legal standpoint, it's almost a nullity. And I think that's what we're here today to decide. So we'll decide, I guess, whether that matters or not, right?
and the question is, again, another way of saying that is, was there prejudice?
Okay.
I turn you to cat withholding, because I don't
Yes.
know if I really understand the government's argument here.
Yes.
So you concede, just make sure, this isn't intended as a gotcha, I'm just trying to make sure we're on the same page. You concede the IJ erred in applying the particularly serious crime bar to that, right?
To withholding, correct.
Okay. And so the argument that you make is that that's harmless error because he didn't challenge that, because the BIA sort of affirmed that. I read the BIA as affirming that on a mistaken waiver holding. I understand the BIA is rejecting that claim under the belief that he did not renew that claim before the BIA. And when I review his BIA briefs, I think that's just wrong. So what's your response to that?
Well, that's not the way we read it, Your Honor. The way we see it is that he waived asylum. So the IJ made
Right, but asylum and cat withholding are different legal standards, right?
Oh, you're saying, I'm sorry, Your Honor, cat
I'm talking about
withholding,
cat
correct.
withholding.
Yes, correct.
So I don't
now-
understand. I understand the BIA to say, well, he doesn't really I don't read the BIA as affirming the IAJ's decision on the merits. Sorry, cat withholding. Cat withholding, yes.
Okay.
Cat withholding. And
Yes.
I read the BIA as saying he doesn't challenge it, so it's waived, but I just think the BIA is wrong about that. What's your response to that?
Well, as we say in the brief, cat withholding and cat deferral. So the IJ denied cat deferral on the merits.
Right.
He did not challenge that. So in his brief to the BIA, he waived the merits.
Of cat.
Okay.
This is
Of
cat
cat.
deferral.
Yes. So on cat withholding,
Right. Which he did challenge.
he did challenge, and there was a mistake there.
Okay.
Our point is that it's harmless error, because if the court were to remand to consider cat withholding,
Okay.
it would be a futile act,
Why?
because the merits decision on cat deferral necessarily applies to cat withholding.
Through what? Operation of preclusion? Like what? I mean, as a predictive matter, maybe we know what the IJ is going to do, but what, I don't understand, like on a preclusion theory, on a law of the case theory, on what?
No, based on the regs, where the regs discuss that it's essentially one set of facts, one claim. There's no distinction between the two in terms of the evidentiary standard, in terms of how they're evaluated.
But if on remand the IJ were to say, I deny cat withholding for the same reasons I denied cat deferral, wouldn't he then be able to PFR that to the BIA and say that was wrong?
I think that's correct, Your Honor. And as we cited in our brief, talking about a ping pong match where we're moving things
And the
around.
BIA has never passed on the cat merits at all. So how is it harmless error? In this world, he has an ability to challenge an issue before the BIA that the BIA has never passed on. I don't know how that would be harmless error.
He had the opportunity to get the BIA to rule on the merits of the cat denial and did not do so. So that's waived.
I think I agree with you that it's waived on cat withholding. I don't understand how that's waived on cat deferral, which he did try to challenge before the BIA, as I understand.
We agree with you on that point. And again, our point is you send the thing back down.
Yeah, I know what the IJ is going to say, but the difference now is that he has an appeal to the BIA that he could take.
Well,
And he could say, I think the IJ was wrong.
wrong on what?
Whether cat deferral, which I guess necessarily would encompass the BIA being wrong about, sorry, the IJ being wrong about cat deferral. I'm sorry, I'm confusing with all. But yes, I understand he couldn't re-raise the thing he never raised before, but he would still be able to raise the thing he's still raising, right?
Correct. And our point is the ruling would be the same. Necessarily because the merits are the same.
Does the BIA always affirm IJ decisions?
No, of course not.
Do courts always uphold BIA decisions?
No, we're hoping the court will uphold the BIA,
So I guess,
decision here.
so I guess I take your point that I think I know full well what the IJ is almost certainly going to do, but I guess I don't know what the BIA is going to do on a question the BIA has never passed on, and I certainly don't know what this court would do if it was asked to pass on a question that it's never been asked to pass on.
Well, again, our position is the BIA has never passed on that question because it was waived. And I understand your point of the legal argument on cat withholding, but again, cat deferral and cat withholding, same standard of evidence. You're going to get the same decision.
Okay.
To us, remand is futile.
Well, how about another? Could I take you to the inadmissibility waiver?
Sure.
I don't really understand how that would possibly be, even assuming for the sake of argument that you're right about how these two parts of the analysis fit together, why wouldn't this be harmless error rather than lack of jurisdiction?
Well, it's two separate arguments. You know, the first argument is because the decision was made as a matter of discretion, there's your lack of jurisdiction. Harmless error.
I read what was made was an in the alternative decision based on lack of jurisdiction, but I understand the decision to be you're ineligible.
Correct. The decision was you are ineligible, and as an alternative, we would deny it anyway as a matter of discretion.
Right. And so I guess I would just, before we get into it, like whether that works or not here, that strikes me as much more harmless error than lack of jurisdiction.
Well, that's our second argument, that if you do, our first argument is there's no jurisdiction. It was a matter of discretion, therefore the court cannot review it. In the alternative, if the court does review it, then it's harmless error.
Can you ask, I'm trying to understand this. So I understand the IJ concluded that the heightened standard did apply. And I think I understand how the analysis goes there. Can you it's really actually pretty unclear to me. Say for the sake of argument, and again, you're not going to concede anything by positing this for purposes of this question. Say counterfactually, the IJ concluded the heightened standard didn't apply.
Okay.
How does the analysis work then? And I'm not even looking for your argument for why he'd still lose. I'm literally just trying to figure out what questions would the IJ ask if the IJ had concluded the heightened standard didn't apply. What is like the decision tree the IJ would then go through? Because I'm just trying to make sure I understand that.
Well, then I think you have to go through the exceptional and extraordinary hardship analysis, right? So can he show that the hardship that he and his family would suffer is beyond the normal scenario in a removal setting?
So it'd be a different legal analysis. The reason that it matters whether or not the heightened standard applies is because what the IJ is supposed to do next depends on whether that standard applies, right? It affects everything the IJ does after that.
I believe that's correct.
Okay. And would the IJ then, under sort of practice or under regs or under the AG opinion, could an IJ just say, you know what, I'm not going to do any of that analysis, who cares? Because I'm going to skip to the end and tell you that whether the heightened standard applies or not, whether or not he can show exceptional hardship or not, I'm just not giving this guy an admissibility waiver. Can an IJ, as a descriptive matter, do IJs ever do that? And as a matter of practice, could an IJ do that?
I can't answer whether they do, or there's a lot of IJs out there.
Have you seen an example where an IJ ever did that?
I personally have not.
Okay.
And it's not an issue that comes up all that often, Your Honor. I've been in this office for 18 years, and I've never seen it. Does that mean it doesn't happen? I can't say.
So what IJs, as a practical matter, always do is they decide whether the heightened standard applies, they then apply the standard that they think should apply, and they get to this discretionary issue if and only if they get through the other parts of the analysis? Descriptively, based on what you've seen?
As far as I know, that's correct.
Okay.
If the court doesn't have any more questions, we submit that the court should affirm the decision of the Board of Immigration Appeals. Decisions.
Thank you, Mr. Alexander. Patsy?
Your Honors, so on the prejudice issue that Mr. Alexander raised, the letters were a part of it, but it wasn't just that. He was credible and he lacked corroboration, and that's why his claims were all denied. If he had witnesses, the letters, the other evidence he sought to admit, that would have established prejudice. And as to what the IJ could have done, he could have done what IJs do every day. He could have continued the hearing. He could have kept the record open. There are many things the IJ could have done, particularly here where it's a pro se detained non-citizen who had recently had his case transferred, didn't have written notice of it, didn't know where to mail his evidence. That would have been, a routine thing to do, something that the IJ should have done. As for the particularly serious crime bar.
This didn't come up in what do I do about your client's testimony, his explanation of, I didn't want people to know my business, which, let me posit that I completely understand why he might feel that way, but it sort of undercuts the IJ's failure to develop the record if your own client says, why didn't you contact people? It's well, because I didn't want people to know things about me that are, admittedly, again, highly sensitive. I'm not faulting him for feeling that way, but I'm not really sure how that squares with the rest of your argument.
So there he was specifically talking about his romantic partners, and in the next, I think even on the same page, or maybe within the next couple pages, he says that if he knew there was he could bring witnesses, or if witnesses would help him, he'd have them. I think that part is specifically speaking towards romantic partners, because he says he wanted to keep it family based, or he didn't want everyone knowing his business. I think that is just talking about partners. The other piece, though, is if he would have understood kind of, how that corroboration, that this rested on corroboration, he could have better done a cost-benefit analysis of, is it worth telling romantic partners about this? Is it not? He really didn't understand what he was supposed to be establishing, that he could have witnesses. So there's several components that that could have been a different decision either way. So here, just kind of in summary, the stakes are too high to let this stand as is. He came to the United States at age 2 as a refugee. He's been here his entire life. He's never been to Liberia. Based on his identity, he faces severe hardship if he were to be removed there. This case was confusing in every respect. There were conflicting addresses, shifting deadlines, no notice of the hearing date, no address for where to send his evidence, no adequate explanation of what evidence was needed, how to present it, no explanation of how to present witnesses in a remote hearing. Despite that confusion, Mr. Dion tried throughout. He mailed evidence to the address he was given. He testified at his hearing. He sought to reopen his proceedings when he realized the record was incomplete. He has attempted to comply throughout. During the merits hearing, the IJ found him credible, denied relief based off of this lack of corroboration. The corroboration is the agency's own failure which prevented him from providing the corroboration. The evidentiary gap, it was what prejudiced this case. The stakes are too high to deny him the opportunity to present this case on a fully developed record. The court should vacate the removal and remand so the agency can adjudicate his claims properly, with proper notice, correct legal standards on a complete record. If there's no more questions, Your Honors.
Mr. Tassi, I note that you're court appointed. I want to give you a special thanks on behalf of the Fourth Circuit. We depend on lawyers like yourself to handle these cases, and we appreciate your very able representation. Mr. Alexander, your representation of the Attorney General of the United States. With that, we can't come down in our normal fashion to greet you in handshakes, but no, nonetheless, it's just as hearty and authentic virtually. Appreciate it, and be safe in this weather. Take care.
Thank you, Your Honor.
Thank you.
All right, bye-bye. All right, we all here? Ms. Butler?
Thank you, Your Honor. May it please the court, Megan Butler on behalf of Jellin. In 2018, Steves argued that it could not build its own door skin plant and that it faced the irreparable harm of going out of business without divestiture. This court affirmed divestiture on that basis, but it left open the possibility that, quote, the district court may have to revisit its ruling when it came time to issue a final judgment. In the 5 years since, that central premise for divestiture, the threat to Steves' survival, has entirely evaporated, and it did so before any final judgment issued. Today, Steves has actually built its own plant, and it faces no risk of folding with or without divestiture. That is admitted and undisputed. The district court expressly stated in its decision, quote, Steves no longer faces the risk of extinction. That extraordinary and undisputed fact alone warrants Rule 60b-5 relief. As the government explained in this case, under CASA, only Steves' continued irreparable injury is a legitimate predicate for divestiture. Now, Steves is trying to speak today on behalf of others, on behalf of independent door skin purchasers that don't have their own plan. And it says that divestiture is needed to help them. But Steves is no longer an independent, and it can't obtain relief on their behalf. In fact, the only actual independent that has weighed in here has said that divestiture will harm it, not help it. The district court's refusal to revisit its decision and vacate the divestiture requirement was error. Now, I want to start with where there's some agreement in this case. Jellin and the government agree that divestiture is only appropriate if Steves has ongoing irreparable harm.
See, when you said wait, when you said agreement, I was hopeful and optimistic that you were going to tell me something that you and your adversary agree on. Now you're just telling me you and something one of your amici agree on, which isn't really what I would normally call as agreement. But can I take a step back further? Like, I think you're sort of walking the line more delicately than the issue. Can we just all agree that the question before us is not whether equitable relief would have been warranted in the first instance?
Yes, Your Honor, we agree with that.
Would you agree that in order to avoid a 60B modification of a judgment, a party does not have to start at the beginning and prove their case all over again, because that would completely undercut the limits of 60B?
Yes, we agree with that, and we're not asking Steves to do that.
Except you are, though, because you seem to be suggesting over and over again the question is whether they could satisfy one of the requirements for injunctive relief if we were deciding that question de novo today. And I just don't understand how you can possibly square that idea with 60B.
So, no, Your Honor, let me clarify what we're saying. Gelman bore the burden, and Gelman satisfied its burden of showing that the original irreparable harm doesn't exist. Now, that is where we all agree. Even Steves, our adversary, agrees. There is no longer the original irreparable harm that led to divestiture. Gelman had that burden, and it satisfied that burden. We are entitled to Rule 60B-5 relief at that moment. Now, that does not mean that Steves cannot now say, well, things have changed. We have new injury and we need a remedy to remedy that injury. Sure. But if Steves wants to do
So on that front, by the way, do you agree that in our previous decision, we vacated a future lost profits award for them on the theory that they were going to get divestiture? So just so we're clear, if you were to win this issue, the issue of future lost profits comes right back on the table, right?
No, I don't agree, Your Honor. So yes,
What? That was the entire basis on which we vacated it in our previous decision.
Sure. So this court did vacate the lost profits award, but it did so because it was based on a future uncertainty whether Steves would go out of business. That was the issue was if divestiture doesn't happen, then what we suspected would happen, what the jury suspected would happen, is that Gelman wouldn't give Steves door skins, and that would force Steves out of business. So it needed the lost profits of not being in business, 8 years worth of its business profits. What this court said in 2021 was, well, if that might not happen, Gelman might all of a sudden decide to give Steves those door skins, and that's why we have to vacate the lost profits award. It's based on a future uncertainty that might not happen.
So if I simply read a different opinion as fundamentally not saying that, if I read it as saying the reason we're vacating this award is because of the divestiture order, you agree that would reopen this topic, right?
I mean, with the caveat that I disagree about the reasoning, it might reopen the topic, and that would at best be a reason to remand this for a determination as to whether the speculative future lost profits have now, there's now harm that would merit future lost profits. But again, I think that was based on the idea that there was future harm of Steves going out of business. That's not true anymore. Steves will not go out of business, and Steves' counsel said below, quote, at JA 489, it's true that we won't go out of business once we have a plan. And the district court at JA 2539 says Steves no longer faces the risk of extinction.
So that
this
suggests,
is an undisputed fact.
That suggests that some of the irreparable harm, and maybe most of the irreparable harm that formed the basis of the original order, no longer exists. But you jump to saying that they've essentially conceded they have no irreparable harm, and I'm not sure where they've conceded that.
Let me clarify. They have conceded that they do not have the original irreparable harm that led to divestiture in the first place. That was the whole thing in 2021. What this court found is that they would go out of business. That was the only future harm proven, and so it needed the extraordinary remedy of divestiture to solve that. I agree with you that Steves is now coming forward and saying, well, wait, we have new irreparable harm. There are at least two problems with this. One, as a legal matter, you cannot sub in new irreparable harm into an old equitable analysis.
This is a real heads I win, tails you lose analysis. So when things change that benefit our client, the client who lost and had a judgment against them affirmed, your view is anything that changes that benefits us reopens everything, but anything that changes that benefits them is off the table. That just seems positively bizarre to me.
No, and I agree, Your Honor, that's not what we're saying. What we are saying is that Gelman was entitled to relief from divestiture when it proved that there was no longer irreparable harm. Now, Steves can come forward with new irreparable harm, and it did. However, it can't say new irreparable harm fits in the old equitable analysis. If Steves wants to prove new irreparable harm, it needs to reprove the eBay factors and show that the remedy it's seeking is tailored to that harm.
But see, now I'm right back to you're right back to like this is again. I feel like at every point someone pushes that this doesn't really work on 60B. The response in your brief and your response in oral argument is to go back and assume that we're just deciding today whether we should order this. and just gut the entire 60B part of it.
Again, Your Honor, I disagree, and the government in this case has said that what
I have a
we
bunch
need-
of questions for the government, I assure you, about their view of CASA, which strikes me as an egregious overreading of CASA.
Okay, fair enough, but even at a minimum, we all agree that the original irreparable harm is gone, and you do need irreparable harm for injunctive relief. Now, there are two problems, and I just want to get to
Let
the
me ask you
second
this.
problem.
Counsel, let me ask you this, because of what we do, if we do what you are asking us to do, how does that impact finality? And it seems as if it would undermine the brown shoe two-step process. I mean, we're just gonna keep going back and forth. How does that impact finality?
Sure, Your Honor. So I think we have two arguments here. One is under Rule 60b-5, and again, that is that in this particularly extraordinary circumstances where we have a concession that the original irreparable harm is gone, Geldo is entitled to Rule 60b-5 relief. Now, on your question, you're talking about brown shoe and the second step of the two-part framework. For that, I think it's important to remember that when this court originally ordered divestiture, it said that the district court might have to revisit its original divestiture decision, that Geldo could challenge the ultimate buyer. There was never going to be a world in which there was no uncertainty. And that, I think, is a misstatement, is a little unclear from Steve's brief. They suggest that any uncertainty at all would undermine the framework. That's not true. There was always uncertainty. And the brown shoe framework actually would have worked in this case. We would have divested and we would be done here as of 2022 when we had a bidder and the special master recommended divestiture. Gelman defended the recommendation of the special master, said that we should divest. The reason that fell through, the reason brown shoe didn't work, is because Steve's objected to that bidder because it wanted to buy the plant. That's what derailed the process. And then in the second round, we were again ready to divest. We had a bidder. We entered into exclusivity with that bidder. We were doing, intense negotiations, and it was that bidder that pulled out. It was not Gelman. So when we're talking about the brown shoe framework and whether it's impossible, I think it just doesn't comport with the facts on the ground. Gelman was prepared to divest, and it all would have gone to plan. The change was that Steve's no longer faces the basis for its irreparable injury. It does not face the threat.
I just feel like the last several minutes of your argument, I feel like I'm just hearing Justice Harlan's dissent in Brown 2. I feel like everything you're saying is Justice Harlan's dissent in Brown 2, and I don't know what to square with that.
I mean, I disagree.
How is this final? It'll be subject to being redone over and over again. Everyone's going to have to, that's everything that Justice Harlan argued in dissent in Brown 2. Brown 2, sorry.
Sure. Okay, well, I think the majority in Brown Shoe said that we want to avoid relitigation of settled issues, for example. To begin, we're not asking to litigate any settled issue. No court has actually decided that divestiture is in the public interest today. No court has answered that question.
Okay, and follow-up question. What court says that at a 60B analysis, you reweigh the equitable factors? I can't find a single decision that says that.
And to be honest, we're not asking that. So I just want to separate the two parts of our argument. One, we have Brown Shoe Step 2, which says there are new questions that have never been resolved, including whether it's in the public interest for this to happen. On those questions where this court said the district court's going to have to look again and may have to revisit its analysis, on that step, there's been no relitigation. There are new questions. Now, to your question, Judge Heitens, on Rule 60B, Gelman had the burden and carried the burden of proving that there is no original irreparable harm. Not only that, there is no evidence of any irreparable harm. And I want to talk about Steve's new irreparable harm. Steve's has said that it's received some defective door skins and that is new irreparable harm warranting divestiture. Defective door skins, a defective widget, is classically compensable. So what it has said is that actually the defective door skins are going to affect its goodwill and reputation. It is two pieces of evidence. One is a declaration from Sam Steve saying it has received defective door skins, and two is an earnings call transcript where Gelman's CEO said there's been some quality problems and it's working to fix those quality problems. There is no evidence that a single customer even knows about those defective door skins, let alone that a single customer's perception of Steve's reputation has been affected. There's no evidence that the merger caused those defective door skins. They could have been caused by an aging employee workforce, the retirement of a key employee, a broken machine. All of those could have caused the defective door skins. And there's also no evidence that these defective door skins are going to cause future harm, that they're going to continue into the future. In fact, the earnings call transcript that Steve cited has Jeld-Wen CEO saying that we're going to try to fix the problem. We're not going to keep giving you defective door skins. Corporate litigants come to this court every day seeking emergency relief because a contractual counterparty has given them something they don't want, a defective widget. And what this court says, this is Williams and DiBiase, is that you need evidence of irreparable harm. If this court says that a defective widget is enough to establish irreparable harm, I suspect that you're going to receive a lot more emergency applications for relief. And that's just not the law. Now, we have no irreparable harm left to solve, but we've also solved some other problems. This court in 2021 wanted to get rid of the duopoly between Jeld-Wen and Masonite. Here's what Edward Steves had to say about that. Jeld-Wen and Masonite were, quote, pretty much a duopoly, and, quote, when we put our plant in, that's going to eliminate that and give more choice to our customers. That's at JA 983. This court also wanted to help the independents, and it thought that divestiture was necessary to protect them. Now, Steves and Woodgrain are making a lot of claims on what will help the independents. They are not independents. They both have their own plant. The only independent that has weighed in here has said that divestiture will harm it, not help it. So given the facts as they currently exist, we would submit that the court should hold that Steves needs ongoing irreparable harm, the exact position that the government has taken in this case. It not only doesn't have the original irreparable harm, it has no other irreparable harm. And so the divestiture requirement should be vacated. Now, on the second step of the brown shoe framework, the point I'd like to emphasize is that there are questions that haven't been resolved. No one has considered whether a below value price can be outweighed by defective door skins. That's never been resolved. I see my time is expiring and I don't want to go over. If the court doesn't have any more questions, I'll reserve the balance for my rebuttal.
Thank you, Ms. Butler. Mr. Horwich.
Thank you. May it please the court. Ben Horwich on behalf of Steves. So I'll certainly take the court's direction on what to address, but failing that, I guess I will start with 60B. And what Jeld-Wen needed to show was a significant change of circumstances that rendered divestiture contrary to the public interest. And now significant in that test is not self-defining. We concede that. So we agree that Judge Payne had to look at his prior judgment and at the substantive law to gauge whether Steves' progress on building a plant to serve some of its needs was significant. And of course, Judge Payne knows this situation better than anyone. That this case is now in its 10th year. And I'm sorry, I'm getting some echo. I don't know if that's me or someone else. But he found correctly is that if you assume quite hypothetically that this Athens plant is operating at its theoretical maximum capacity, that would not change fundamentally what this case has always been about, which is this: Steves needs to buy door skins. It's not going to get a complete supply from its own plant, even if we're in the best case scenario. Steves hasn't actually gotten a single usable door skin out of that plant at this point. So Steves still needs to buy door skins. Steves would still be dependent on Jeld-Wen for those door skins. Jeld-Wen would still have the power and incentive, that's a quote from Judge Payne at JA 2534, still have the power and incentive to withhold door skins from Steves to poach Steves' customers in the door market. That's what the economists call foreclosure. So Steves is going to be unable to serve customers, and so Steves is going to lose customers. Now, what's different here is, yes, if things go well with the plant, that is still hypothetical, that's still an if. What's different is that the next step of Steves then goes out of business may instead be Steves loses a good number of its customers. But we have a term for losing customers but not going out of business. That term is loss of goodwill. That's a classic harm in antitrust cases, and it's a classic irreparable injury. And so that really ends Jeldwin's appeal on the 60B side any way you slice it, because either you could say the change is not significant in the relevant antitrust sense of altering the competitive conditions and eliminating the power it has over Steve's to foreclose. You could do it in the language of the antitrust cases applying Rule 60, cases like United Shoe and Kodak, and even going back to Swift before the adoption of the federal rules, but that's an antitrust case in equity, trying to decide what to do about a judgment. The purposes of the decree haven't been achieved. We still have this problem. Or you could go under the four-factor test and you'd say, well, we still have irreparable harm. And so any of those comes to the same thing. And I mentioned Swift because this is not a new thing. 100 years ago in Swift, the court recognized, and I think this goes to Judge Heitman's point about how you have to have some value for the finality in a judgment like this. Swift said, I'm just quoting here from 286 U.S. at 119, we're not framing a decree. We're asking ourselves whether anything has happened that will justify us now in changing a decree. The court goes on, life is never static. And the passing of a decade has brought changes to the grocery business as it has to every other. The inquiry is whether the changes are so important that dangers once substantial have become attenuated to a shadow. And so
And do you think all of that is Swift is good law? Because there's some language in Swift that I think comes a little bit later that I know is not good law anymore.
Yeah.
So what do you, that like attenuated to a shadow, you think that part survives the abrogation of the part of the language in Swift that we have abrogated?
So the colorful language in Swift, I think, has been perhaps superseded by the language that I would give the court from United Shoe, right? Which is and this is United Shoe 391 at 248. A decree, quote, may not be changed in the interest of the defendants if the purposes of the litigation as incorporated in the decree, the elimination of monopoly and restrictive practices have not been fully achieved.
And so on that front, there's these other 60B cases that are more even recent than that, but those tend to involve government defendants, and you think, like, I guess what I'm trying to figure out is some of these later cases that involve like prison regulations and things like that, where the court seems to make 60B even easier to get. But I'm trying to figure out in those cases how much of what's driving the analysis is that like having a court enjoin the federal executive or a state is kind of a big deal from either a separation of powers or federalism. So we have like Agostinian cases like that. So because there are other cases that involve that setting where the court seems even more pro-change under 60B. And do you think those cases are just about government defendants, or
no? I don't think they're just about government defendants. But if I can venture an analogy, I think that cases, like a Horn against Flores case or an Agostini case, where you're talking about terminating a structural decree that's trying to reform, say, an entire prison system, a whole bunch of prisons, or reform an entire education system, a bunch of schools. I don't think the decree would be terminated if, some share of the schools, we fixed the problem, but there's still a share of schools where the exact same problem exists and the decree has yet to run its course. And I think it's a rough analogy, but that's the analogy here, which is it's true that Steve's, again, in the hypothetical where Athens is up and running, it isn't, right? But in that hypothetical, we can hope that Steve's will not lose all of its customers, but we're still in a situation where the exact same antitrust concerns apply, that Steve's will lose a significant fraction of its customers. And that's the goodwill issue. And so you wouldn't terminate a decree that had accomplished a reform at 60%, 70%, I don't know what the right percent of the relevant locations is, if there is still work to be done. So I think that's how I would square up those cases. And so from there, this court's review of this decision, which of course is for abuse of discretion, and there's good reason that review is deferential in this setting with a court that Judge Payne has had to sit with this case, as I say, we're coming up on a decade now, and has had to continue managing it even during the pendency of the prior appeal. This has been a continuous job for him in one way or another. And I think what he understood is...
You address I'm not sure how legally relevant this is, and look, there's a fair amount of finger pointing, like why is this final sale price so seemingly bizarrely low? But I guess, and maybe I'll ask your friend on the other side during rebuttal, but their first shot is there was a great offer until your client blew it up because it wanted the plant for itself.
Sure.
Could you address that?
Yeah, I'm happy to address it. What we raised was really a question of law, which was that we argued at that point that the special master had disqualified us, or really his antitrust advisors had disqualified us at the threshold because of the fact that we would become vertically integrated. And that is to say, we also made doors. We wouldn't be making only door skins. And we thought that analysis was incorrect as a matter of law, and we said we should be in the pool. We didn't say you have to give it to us. We certainly didn't say that, and we certainly weren't there trying to blow up another deal. We genuinely believed and put in considerable evidence on why we thought the analysis was simply wrong and mistaken. And the fact that the bidder in that case decided to withdraw, there's not a record on what their reasons were. This is very much a post hoc ergo propter hoc kind of reasoning from Jeld-Wen on that bidder. It's just that they left when they decided that, okay, we don't want to deal with this, I guess. But
why'd you announce your plant 2 days before the second round of bidding closed?
So the announcement of the plant came in the context that we had to disclose what we were doing. We're not going to be there and say we're secretly doing this. I do want to remind the court that and perhaps correct an inadvertent misstatement from my friend. The suggestion that we could not build our door skin plant is not quite right. What we said was we couldn't build it in time. The issue in the prior appeal was, or in the prior jury trial really, was that the supply agreement for us was going to expire in September of 2021. So the question was, could we build a plant in time to pick up where Jeld-Wen was going to cut us off? And this court recognized that point in the prior opinion. This is at page 702. Steve's didn't abandon its interest in building one, and it was continuing to explore the possibility when the trial in this case began. So I'm happy to give the court a bunch more record citations for this. But it's not that we were lying or had some secret plan. We've always been forthright about that. This is an exceptionally difficult industrial project. If the court wants to learn more about this, it could go back and look in the record of Jeld-Wen's attempts to stand up its Dodson plant, which may very well be the last one built in the world, and that was started about 20 years ago. And so this is not easy, and although, as I've alluded to, it's happened after the district court proceedings closed, but we've been working, but we don't have any usable door skins out of our plant today. So from the point of view of this motion, if Jeld-Wen's position is that this motion should have been granted back in December of 2024, we'd be running on 13 months here with Jeld-Wen having the plant. In their view, the case is over. Steve's gets no more remedies, and that's it, which I think can't be the correct answer here. I do want to respond to the point about the these are just defective door skins and we can pay for them, and we'll pay for them. That's not the issue. If the door skins are defective, you can't make doors with them, and you can't supply your customers. And there's a long record here that supported Judge Payne's entirely reasonable prediction about what happens in this market when Jeld-Wen has the ability to control supply. So go all the way back, right in 2012, this is at page 700 and 701 of the court's prior opinion. Right around the time of the merger, Steve started to see quality issues with the door skins. Then we had the bunch of the pricing and payment and reimbursement issues in 2013, 2014, 2015. That's all chronicled at JA 601 to 604. Then in 2019 and 2020, while the prior appeal in this case was pending, there was a separate lawsuit between Steve's and Jeld-Wen, also before Judge Payne, because Jeld-Wen refused to fill Steve's orders during that appeal. That's published at 612 F Sup 3rd 563, and Judge Payne is referencing that in footnote 11 of his 60B opinion on page 2526. And then in 2024, we have this defect rate skyrocketing again, which is basically withholding door skins from us. If you give us useless door skins, we can't serve our customers. So Judge Payne's view that that this portended a loss of future goodwill is absolutely right, because that has been the pattern of this case throughout its history. And so if we're making a predictive judgment, which all of these are, it's prospective relief, this is absolutely well supported. And from there, you get to the question of, well, is this the right remedy to go forward with? And as this court said in the prior appeal, divestiture is the remedy best suited to redress the ills of an anti-competitive merger. That's how you address things here. And I guess I would close just on the point about CASA, because we haven't had the opportunity to address that. It wasn't in our brief; it had just been decided. CASA is addressing, I think, a circumstance that doesn't really fit the problem here. CASA asks the question of what do you do when you have an injunction that's too big, bigger than necessary to redress the harms of the party in front of it. But in this case, what you have is divestiture, which is kind of a unitary, indivisible remedy. You can't peel away layers of divestiture. And so in order to remedy Steve's harms through the divestiture.
So do you think the CASA analogy would be something like, let's say this injunction ordered the defendant to sell to people other than your client?
Yeah, that would be a correct analogy. And conversely, CASA gives, as a counterexample, a nuisance action, which I think is much more like divestiture in the sense that abating a nuisance might help, the neighbor to, might be brought by the neighbor to the north. I see my time has expired, but if I could finish the thought.
Let me finish your answer, yes.
Abating a nuisance might benefit the plaintiff neighbor to the north, but it's also going to benefit the neighbors to the south, but that's incidental and not a reason not to do it. That's the case with divestiture too, which is that it is going to structurally repair things, but really this is still benefiting Steve's. Thank you.
All right, thank you. Ms. Badaracco?
Thank you, Your Honor, and may it please the court. Anthony Badaracco from Dorsey and Whitney on behalf of Woodgrain. This court, in its 2021 decision in this case, held that Geldwin can, quote, challenge whether a sale to the particular buyer will serve the public interest. And Geldwin has done that, and that's why we're here. And I don't think there can be or is any legitimate argument that Woodgrain is not capable of or incentivized to operate the Towanda facility profitably and successfully and in the public interest. Woodgrain's got decades of industry experience. It's a previous part owner of the facility. And critically, I think the court below found that even absent any demand at all from Steve's, based on Geldwin's own financial reporting before the divestiture, Woodgrain could profitably operate Towanda. And, I think the court, to the extent that Geldwin does challenge Woodgrain's suitability to operate the facility, should take any such argument with a grain of salt, because since the divestiture, which closed a little bit more than a year ago, Geldwin and Woodgrain are direct head-to-head competitors for the sale of molded interior door skins. And so Geldwin's got every incentive competitively to undermine Woodgrain in the marketplace. Respectfully, I don't agree that the record from the court below supports the notion that the eventual $115 million sale price for Towanda was anything less than a reasonable price and a fair price under the circumstances. Now, what are those circumstances? Well, of course, it was a forced sale. It was not an open market sale by a willing buyer, and bidders knew that. Geldwin got far more than the price that it had paid for Towanda in 2012, and that doesn't even take into account the monopoly profits that Geldwin earned during the time when it owned and operated Towanda. And there are a couple of critical factors that I think the court should also consider. Steve's wasn't the only party to object to a bid. Geldwin objected in the second round of bidding to a bid that would have led to a sale, pursuant to which Geldwin would have gotten substantially more money than it eventually got from Woodgrain in the third round of bidding. And so Geldwin bears some responsibility for the fact that the purchase price ended up where it was. The other factor is that Geldwin insisted on maintaining its right to an appeal, which of course it was perfectly reasonable for it to do, but the reality of that is that Woodgrain knew when it was submitting its bid that it wouldn't have certainty that it would continue to be the owner of Towanda, and that affected its willingness to pay for the asset. Now, the final point that I'd like to make, if the court is interested, is to address just briefly Towanda's performance since divestiture, based on a report issued by the special master that the lower court transmitted to this court. My time's almost up, but I'll briefly address that if the court would like.
You may.
Thank you. So in July of 2025, the district court charged the special master with visiting Towanda, speaking with Woodgrain and speaking with Steves, and producing a report. The special master did so. And at docket number 2724 in the district court, Judge Payne ordered the clerk to place that report in the record of the Fourth Circuit. And the report indicates a few things that I think are pretty significant, that Woodgrain is committed to successfully operating Towanda, that it had secured long-term contracts with other customers, not just with Steves, that the door skin defect rate had materially dropped since Woodgrain took over the facility, and that Woodgrain had committed millions of dollars in capital expenditures to support the facility's long-term effective operation. And I just think those are all things that the court can and should legitimately take into account in weighing the equities that are presented here. Happy to take any more questions the court has, otherwise I'm happy to rest.
Thanks, Ms. Rocco. Ms. Herzog?
May it please the court, Ali Herzog on behalf of the United States, here as amicus supporting Steves. The United States has a strong interest in protecting the availability of divestiture as a key antitrust remedy. Even in private cases, divestitures can be an important supplement to government enforcement. I would like to focus on 2 points. First, antitrust injuries stem from harms to competition and thus are remedied by restoring competition. While a court may only give a remedy to the parties before it, antitrust remedies will often have incidental benefits for third parties because unfettering a market typically unfetters it for everyone. As counsel for Steves mentioned, divestiture is much like the relief that might be ordered in a nuisance suit, where requiring the defendant to turn down their music benefits the plaintiff's entire neighborhood, but is still proper relief to give to the plaintiff. Here, the district court's findings show that Steves is still suffering irreparable harms caused by the anti-competitive market conditions that necessitated the divestiture. While Steves is no longer at risk of going out of business, the district court found that without divestiture, Geldwin will retain the power and incentive to deprive Steves of the ability to meet its customer demand and to compete for new business. Having to transact business under these anti-competitive conditions continues to harm Steves and to harm the goodwill between Steves and its customers. Second, like any antitrust remedy, a divestiture should not be vacated unless its purposes have been fully achieved. The antitrust laws would be undermined if defendants could continually relitigate relief before competitive harms have been eliminated. Here, Geldwin unlawfully acquired market power by buying Towanda, and the district court ordered divestiture to undo that unlawful acquisition, and this court affirmed. Thus, on its Rule 60 motion, Geldwin had to show that a significant change in circumstances has restored competition and rendered divestiture of Towanda, the fruit of Geldwin's violation, no longer equitable. Geldwin's argument for changed circumstances based on a simple head count of doorskin manufacturers is unavailing. The state of competition cannot be determined through such simple arithmetic. Indeed,
Can I ask you, you realize you only have a couple minutes. I just want to ask you about the government's position on CASA, which I've previewed that I think is way overbroad. Why isn't CASA a case about the scope of injunctive relief under the Judiciary Act of 1789 against the government, which I've just identified 2 rather big differences between CASA in this case?
under the Clayton Act, relief in antitrust cases, equitable relief in antitrust cases is available under the same conditions as other equitable
It's just
relief.
when I read
So-
CASA, there's a lot of stuff about how enjoining the whole government's conduct against the entire world is a really big deal and gets really pretty far from what courts of equities do for the benefit of people who aren't before the courts. And this just feels like a radically different situation. Like, I guess what I'll say, maybe the constructive, why is the Ninth Circuit's Epic decision wrong? Because I just read that and thought, this seems right.
What I would say is, I think that this decision, this case, similar to the other case, actually is really about what does complete relief look like for the plaintiff. And in an antitrust case, that looks different than it did in CASA. So as Your Honor alluded to before, in CASA, the relief was being ordered for the plaintiff and potentially also as applied to lots of other folks. In an antitrust case, relief has to be ordered or is generally ordered through the mechanism of restoring competition. And so what that means is there may be situations where relief, like a divestiture, you aren't really peeling off specific relief for the plaintiff. You're restoring competition to the market, and through that mechanism, you are fixing the plaintiff's harms. I'm sorry, I see I'm far over my time. I'm happy
Go
to
ahead, finish your thought with Judge Hyden's question. Go ahead.
Thank you. And so there may be cases even with injunctive relief where, injunctions that are aimed not like in the Epic cases where injunctions that are aimed not solely at the plaintiff can still be serving the purpose of restoring competition and thus a mechanism for remedying the plaintiff's injuries. Here, because Geldwin failed to show that competition has been restored to the market, the district court properly denied its Rule 60 motion, and that decision should be affirmed. Thank you.
Thank you. Ms. Butler, you have some time reserved.
Excuse me, I'm sorry. Now you can hear me. I'd like to start where the government left off, which is the evidence of irreparable harm. So the government has said that there is evidence of irreparable harm in the record. But what the government said in its brief is that we don't actually know what that evidence is. You know what that evidence is. We all know what that evidence is. It does not exist. There is no evidence of a loss of goodwill or reputation. Now, counsel for Steves mentioned this allocation dispute from 2020, and the district court did the same thing. The district court said, Geldwin, you previously engaged in this allocation issue, and so you can be thought of as, continuing with any competitive harms. But if we look at that allocation dispute, we have the same issue of causation. In footnote 4 of that decision, the district court, Judge Payne, said, the record here is scant as to whether that antitrust violation, he's referring here to this antitrust violation in this case, caused the damages alleged in this case, and there is dispute as to whether the complaint alleges antitrust impact or antitrust injury. So in that dispute, Judge Payne could not conclude that we were using our market power to cause Steve's harm. I hardly think that that dispute suggests that we have market power that we're going to continue to use to harm Steve's. Likewise, in that case, there was actual evidence of irreparable harm. There was evidence that Steve's had to inform customers that it couldn't fulfill their orders. There was evidence that a future customer wouldn't do business with Steve's. And there was evidence that former customers had gone to Geldwin and Masonite. None of that evidence exists in this case. There is absolutely no evidence of irreparable harm here. The second thing counsel for Steve's mentioned is that this is a fact-heavy dispute, this implication being that we should defer to the district court judge. These are questions of law, Your Honor. It is undisputed. It is conceded in this case that Steve's will not go out of business without divestiture. Yes, it thinks demand for its products will increase. Yes, Steve's would like more door skins and the opportunity to buy more door skins, but it is conceded in this case, and the district court wrote in its decision, that Steve's survival is not threatened. Now, the other thing counsel mentioned for Steve's is that perhaps United Shoes survives these institutional reform cases, and this was Judge Hyten's question. Eastman Kodak is an antitrust decree case, and in Eastman Kodak, the court said that the test is any significant change in factual or legal circumstances. Even if the purposes of the decree have not been achieved, there can be a change to an antitrust decree where there's a significant change in law or facts. That's Eastman Kodak from 1995. And so it's just not true. The test is a significant change in law or facts. The entire factual predicate for divestiture being not true is a significant change in law or facts. And finally, I want to talk about the public interest here. So first, again, no court has considered whether it's in the public interest today for divestiture to happen. That just hasn't happened. Now, the government has said, well, the market has stayed the same, and so has the district court. That is legal error, Your Honor. That's not a factual difference. That's a legal error. Steve's own expert at J1624, from an economics perspective, said, in fact, the market has changed with Steve's new plant. And as a matter of law at trial, the market that was defined was the market for all door skins used in the United States. That includes vertically integrated manufacturers. That's why Masonite, for example, who didn't make significant sales to the independents, was included within the market, because Masonite made door skins that Masonite used in the United States. In the same way, Steve's is now making door skins that it is using in the United States. It is part of the market. It is a third competitor that has been restored to the market. And the district court's reasoning about the public interest turned entirely on the belief that the market was different and that there had been no change in the market. If the court just alone finds that there was a change in the market, like Steve's expert says, and like the jury said, the market that the jury said existed, then there needs to be a remand, because none of the district court's conclusions about any purpose of this litigation can stand up. Because again, the district court only found that the purpose of the litigation hadn't been solved because a completely different market hadn't changed, but that's just not the market. And now finally, there has been a couple suggestions about how divestiture is working and how it might be hard to unwind divestiture. But I want to emphasize that Wood Grain accepted the risk of an unwinding here, and Jeld-Wen and Wood Grain contracted for the exact eventuality that there might be a remand in this case for better reasoning, for a consideration of the equitable factors, or for a reversal. So with that, I would ask the court to reverse the decision below and vacate the divestiture requirement. Thank you.
Thank you, Ms. Butler, and thank you all, counsel. I appreciate your arguments. We normally would come down and greet you, but we can't do that, but we do so virtually, and thank you so much for your arguments, and we'll all be safe. Take care.
Thank you, Your Honor.
Mr. Berman?
Thank you, Your Honor. Good morning, and may it please the court. I'm Stuart Berman for the appellant Earl Griffin Jr. On September 5th, 2019, police executed a state search warrant at Mr. Griffin's mother's house in Calvert County, Maryland, what we've referred to in the papers as the 6740 residence, and also its vehicles outside of it. They didn't find any contraband in the house, but outside in a green Tahoe vehicle registered to Mr. Griffin, they found drugs and a center console, and they found a gun in a bag on the floorboard of the rear passenger side. Government charged Mr. Griffin with 3 crimes. The jury acquitted him of possession with intent to distribute the drugs. They acquitted him of a related 924C charge, but they convicted him of a felon in possession charge relating to that firearm in the back seat, and he received a 15-year mandatory minimum sentence under the Armed Career Criminal Act. I want to focus in this argument on 3 key points, particularly number 1, which is that there was no probable cause for the warrant, and the district court should have suppressed that firearm. Second, that there was insufficient evidence that Mr. Griffin knowingly possessed the firearm, and the district court should have granted a Rule 29 motion. And third, that applying the Erlinger case, which came down after the district court proceedings, this court should find plain error and reverse the mandatory minimum sentence because the indictment didn't charge and the jury didn't find 3 prior drug offenses on separate occasions, and the error was not harmless. As to the remaining issues in the briefs, I would address that in briefs, but I want to start with the warrant issue. You know, Judge Hazel,
Can I just ask, this is literally just a clarification question because I want to make sure we're on the same page. You're not arguing that the execution of the warrant violated what the warrant authorized. The argument is just the initial issuance of the warrant. Is that right?
Correct, Your Honor.
Okay, thank you. That's all I want. Yep.
And Judge Hazel, to begin with that point, recognized that the affidavit for the warrant to search the 6740 residents and vehicles, quote, may not be the strongest search warrant affidavit I've ever read. That's at Joint Appendix 243. But he gave the government and the issuing judge the benefit of the doubt, and he found a substantial basis for the issuing judge to have found probable cause, and respectfully, he was wrong. Because probable cause requires an affiant to show a fair probability that contraband or evidence of a crime will be found in a particular place. That means the 6740 residence itself, not the Kent Bottom area generally. You know, the Fourth Amendment requires probable cause for a specific house, even in a high crime area, as this court has recognized in its reasonable suspicion cases. You know, you have to have particularized evidence for a specific place. And we submit that even with deference to the issuing judge, even allowing for reasonable inferences, the warrant here lacked a substantial basis for probable cause. And even though this affidavit was lengthy, it said very, very little about the 6740 residence. In fact, when you strip out the portions that don't relate to 6740, it's accurate, I think, to say this was a bare bones affidavit. Search warrant affidavit made only 3 allegations about 6740. One of them was hopelessly stale, which is that there was a search in 2006, 13 years earlier, that resulted in the seizure of drugs and ultimately in the conviction of Mr. Griffin. The other 2, one was from April of 2019, 5 months before the warrant, in which officers allegedly observed that Mr. Griffin's son did a hand-to-hand transaction in the yard of the residence, which yielded 0.5 grams of cocaine base. But the application did not state that the person believed to be Mr. Tyleek Griffin, that is the defendant's son, was seen entering or exiting the 6740 residence before or after the suspected sale. That's at Joint Appendix 44. The only other thing in this affidavit about the 6740 residence was that in August of 2019, a month before the warrant, officers allegedly observed Mr. Griffin's brother Desmond was present at Kent Bottom, the neighborhood, not the house, during several suspected CDS transactions, none of them proven because there's no evidence, there's no representation about any arrest or any seizure of drugs, and was seen walking in and out of 6740 before or after these suspected transactions. That's it. That's all that this affidavit says about 6740. Look, I understand the court has upheld warrants to search suspects' residence because of evidence of suspects' involvement in drug trafficking combined with reasonable suspicion that drug traffickers store evidence in their house. 6740 wasn't Tyleek Griffin's house. The affidavit, in fact, acknowledges that. And there was no fresh evidence that Desmond Griffin sold drugs. And Earl Griffin's 2006 split, as I said, was 13 years old. And the affidavit also referenced certain 2014 and 2015 offenses of his that didn't take place there. I think it's notable what the district court said, that the Tyleek, at Joint Appendix 244, it said that the Tyleek Griffin and Desmond Griffin events by themselves wouldn't be sufficient, but when taken as a whole, when looking at all the evidence that's in the affidavit about this ongoing, frankly, years-long drive-up drug shop there, even those just small connections to one of those houses, 6740, is sufficient to establish a substantial basis under which the judge could issue a finding of probable cause.
Can I take you to the Leon question? Because the elephant in the room is, even assuming you're right, this warrant was invalid, there's a Leon problem. And the way that you try to get around Leon is Lyles, and I think that Lyles seems pretty clearly distinguishable for 2 reasons, and I'd like to get your response. So first, the thing is that this court's opinion in Lyles emphasized the incredible scope of what the warrant authorized and how it had basically nothing to do with the probable cause. That was thing 1 we said in Lyles. And in 2, in Lyles, the district court had granted suppression. Those seem like 2 pretty big differences, so why isn't that suggest that Lyles isn't super helpful for you on the Leon issue?
Well, let me come at it this way, Your Honor. I think that with 2020 hindsight, I would place less weight on Lyles and more on Doyle and Wilhelm. Really Doyle, I think, is the best case on the good faith issue. I think it's pretty well established by this court's good faith cases that when we're in this context of looking at the probable cause issue, we're talking about the 3rd prong of the Leon exceptions, namely that where a supporting affidavit is so lacking in indicia of probable cause as to render official belief in its existence entirely unreasonable. And again, even though this affidavit is more than 20 pages long, when you cut out the parts that don't relate to 6740, it's bare bones. And it's very much on point with the child pornography conclusion in the Doyle case, where this court held that nothing indicated when or if child pornography existed in Doyle's home. We conclude that an objectively reasonable officer would not rely on a warrant application so devoid of necessary information, and that because reliance on the warrant was not objectively reasonable, that good faith doesn't apply. And I think that's really the situation here. I mean, it's tempting to say, well, the officer did this lengthy affidavit that's got these photographs in it and so forth, but once you strip out all the things that relate just to the so-called bad neighborhood here and the other houses in the neighborhood, which are not where this evidence was seized, you just have these 3 items. You just have this 2006 seizure, you have this whatever it was in a yard, not in the house in April 2009, and you have this incidents in August about a suspected transaction, where there's no proof of drugs involved. So we would submit both that there was a lack of probable cause, and that applying particularly Doyle and Wilhelm, that there's a lack of good faith here. So with that, let me turn to the constructive possession issue, which is constructive possession requires two things. It requires ownership, dominion, control over the contraband, or in this case, the vehicle where the contraband was concealed, and knowledge of the presence of the contraband. And the government presented evidence that the car was registered to Mr. Griffin, that he had a key in his pocket, and that there had been this text message from an unknown person about a 40 big boy, which an expert said meant the 40 caliber firearm. No witness saw Mr. Griffin with a gun. No witness heard him mention a gun. He didn't say anything to law enforcement about a gun. There was no surveillance of him with a gun. There was no statement by Mr. Griffin, again, about a gun. They presented DNA evidence. It didn't link him to the gun. There was no evidence about how long.
These all sound like great jury arguments to me, but what I'm not sure they sound like is a good sufficiency argument, because what you've told me is it's in front of your client's house. It's registered to him. The only key that anyone locates is on your client. These seem to be hard arguments that he doesn't possess what's in the car.
Well, to the extent that the court might conclude that that establishes that the jury could reasonably have found ownership, dominion, or control over the vehicle, that still doesn't address the question of knowledge. And it doesn't prove Mr. Griffin's knowledge that firearm was there on September the 5th of 2019. That would be our argument.
How does the expert's testimony regarding the text messages go to the knowledge? The text message regarding I think was the expert testified that the buying, I guess, of the gun.
Well, the text message was from 3 months earlier, and assuming that, reading all the inferences in favor of the jury's conclusion, the jury could have found that he had knowledge as of July 6th of 2009 that there was this 40 big boy, 40 caliber firearm out there. I would respectfully submit that that is not sufficient to establish his knowledge that firearm was in that car as of September of 2019, several months later when the warrant was executed.
Can I take you to the ACA issue?
Certainly, that's where I was headed. That's fine.
Great. So as I understand, there are two issues here, which is how many qualifying convictions he has and whether they were on occasions different from each other, broadly speaking, right? So this question's about the first one of those. What is your best authority for the proposition that if the government doesn't file a 28J letter, it has waived reliance on intervening Supreme Court authority that just directly answers a question?
Yeah, Your Honor, I made the best argument I could regarding that in our supplemental brief. This court held in U.S. versus White that when an intervening decision of this court or the Supreme Court affects precedent relevant to a case on direct appeal, an appellate may raise. Wait,
hold on. What was the word you just said?
May timely.
No. Before that.
Affects precedent relevant to a case pending on direct appeal.
Sorry, the word was appellant, right?
It said, yes. Okay.
Is the government the appellant in this case?
The government is not the appellant.
Is the government seeking to alter the district court's judgment?
The government is not seeking to alter the district court's judgment.
How can the appellee waive reliance on an intervening Supreme Court authority that means they're just right about an issue?
Well, Your Honor, that's why I was more than willing to rest on my brief.
Understood. Sorry. So let's take the occasion. So the occasions question. Let's move to that's fine.
Sure.
On the occasions question, you agree this is totally forfeited?
Well, I agree that we're on a plain error standard.
That's all I meant. We're in 52B land, Alano, Johnson, Cotton, all those cases.
Yeah, right. trial counsel mentioned Wooden at the sentencing hearing, and he came close to identifying the occasion clause issue, but I would concede that he did.
Okay. So, and under Brown, we know this is capable of being harmless, and we know that under Alano, it's even harder under plain error because it's now your burden to prove prejudice. How can you possibly prove prejudice?
Well, Your Honor, I think that if we apply the standard, which I submit ought to be the Sixth Circuit standard in Cogdill, that if just one reasonable juror could find reasonable doubt about whether the offenses were committed on different
that's a harmless error standard. That's not a plain error standard.
Well, I submit that if the error here is that the defendant's Fifth Amendment rights were violated by not being charged in an indictment, and his Sixth Amendment arguments were violated by not having the jury make a finding as to the occasions clause issue, that affects substantial rights and seriously affects the fairness.
But that is the precise argument that United States versus Cotton rejected after Apprendi.
I understand the point. I submit, Your Honor, and if you look at and I see my time is over, if I could just finish answering your question.
Yeah.
I submit that if if you look at the various cases that have come down in other circuits since Erlanger, there's no barrier to recognizing a plain error that is not harmless in situations where the occasions clause issue was not initially raised below. And I see my time is up for additional argument.
Yeah, thank you, Mr. Berman. Mr. Hagan?
Good morning, Your Honor. May it please the court. Timothy Hagan on behalf of the United States. I did not realize that I would need my water. Apologies. Your Honor, I'd first like to address Mr. Berman's argument with respect to probable cause, and then I'd like to address good faith that Judge Heitens had raised. Obviously, the government's position, as we set forth in our briefs, is that there was probable cause in this affidavit, but that is obviously not the standard that this court would need to find to affirm on that issue. It's that Judge Claggett had a substantial basis to come to the conclusion that there was probable cause to search 6740, the residents in this case, as well as the other vehicles that were noted with respect to Part B at JA 51, which was entering and searching any portions of the dirt driveway that is contained on those two other residences on the side, 6790 and 6738. Your Honor, as this court has noted, the court has to pay great deference to the judicial officer who issued the warrant in this case. And here there is a substantial basis that there was probable cause. As we've noted in our papers, there were not just the overwhelming evidence of this being a stop-in, stop-drive-up drug shop, as Judge Hazel noted and as my friend Mr. Berman noted, but also we have the ties, the nexus to the 6740 specifically, some of which were noted by Mr. Berman. I'd also note, though, that one of the important things to consider here is that when we look at the common sense and the entirety, the totality of the information that was received, Judge Claggett did have a substantial basis to find that there was probable cause and that there was a nexus to.
Mr. Hagan, one of the problems that with this, you got 20 pages of can't say you certainly had a lot of pages, but this seems to come dangerously close to a neighborhood, that a neighborhood labeled by the police, I suppose, based on this record, as a drug, open air drug, that kind of thing. So the problem is you swoop in everybody who lives in that area. And therefore, just people who live there because that's their home and that's their neighborhood. So certainly we don't want that to be the basis for a probable cause. So and with that in mind, looking at this, this was September 2019?
Yes, Your Honor.
All right, what's the most recent thing that you have in that warrant that happened at that address? What's the most recent, meaning in terms of from that date going backwards?
The most recent was
most recent thing that's observed that occurred at that address before September 2019. That's in the four corners of those 20 pages. What's the most recent thing? You know, you got back 13 years. You go back, somebody was convicted of something. But tell me what's the most recent thing that's in there?
Yes, Your Honor. At JA 144 and 145, there's a reference to an August 9th of that year, 2019, where there was. Happened? I'm sorry, Your Honor.
No, go ahead. Tell me what happened at that address. That's in there. Now, I don't want you to. This is not analysis. This is just reading. What's in there that happened at that address in August 2019?
At that address, Desmond Griffin, who had been tied to that address, had been indicated previously in the affidavit as a street level to mid-level distributor who was operating there, who had claimed 6740 as his address, was previously arrested on August 9th, during the day where there was observed significant vehicle and foot traffic coming in and out, as a number of transactions are described at 144 and
Going in and out of what? Where?
in and out of that location at 67, not the residence 6740, but the driveway that comes off of Route 2 that is about 50 yards from that residence, going into
Okay,
that.
the driveway wait a minute, the driveway belongs to the persons who own that address? No, right?
No, that's a shared driveway, Your Honor.
That's what I'm saying. Okay, so that's my question is, happened at that address. That's a driveway that the public can use, correct?
Yes, Your Honor.
Yeah, and they do use it, correct?
Yes, Your Honor.
All right, now, so go back now, tell me again, my question is, what's the most recent thing that you tied to that address, meaning that home or its curtilage?
The description at 144 of the drug activity that was seen there on August 9th of 2019, when they described the significant amount of activity that is going on there that day, that's drug transactions that they're observing.
But you told me that was at the driveway. You didn't
Yes.
say it was at the home or, it doesn't say it happened at that home or property that's owned by the owner there. I mean, that's what I'm saying. You're really putting this in, it's all the neighborhood. Yes, if you live in a place that the police have designated as a drug open air area, if you walk down the street, you could say, I saw the person walking past that house and in that neighborhood. Well, then I'm in the swoop of how you have now defined what your probable cause is. You see, this is geographical now and neighborhoods as opposed to specificity of activity of drugs. So going back to my question again, what is the most recent thing that you have? Because so far you haven't answered that at all. You're trying to say a driveway, which you admit is not their property nor their curtilage. Tell me what it is most recent to the date of the execution of that warrant at that address or curtilage. And don't go to the other one, because the other one is, give me another one, because you're still talking about activity in the driveway, and that doesn't cut it, answer my question.
Yes, Your Honor. On that date of August 9th, 2019, there's a reference to Desmond Griffin present at several transactions that I described a moment ago when I was answering your questions that are occurring right there at that driveway, and walking in and out of 6740 before and or after those transactions. So to answer Judge Gregory, your question, the reference to 6740, the most recent one was August 9th of 2019. It had to do with Desmond Griffin, who was identified in the affidavit elsewhere as a street level to mid-level distributor operating there at that location, has claimed 6740 of his address when previously arrested, has been during the investigation seen entering and exiting 6740. Obviously, as Your Honor noted, there's also the reality of the previous time, the 13-year prior time where he was at 6740 during the execution of that search warrant where Mr. Earl Griffin was flushing marijuana. But finally, there's also this August 9th of 2019 that I just noted, where all of this trafficking is occurring, and Mr. Desmond Griffin, and it's described at length in multiple paragraphs, Mr. Desmond Griffin is present for that several transactions and walking in and out of 6740 before and or after those transactions. So that's the most recent time, Your Honor, that to the execution of this search warrant.
So you observed him, he was observed actually possessing and distributing drugs?
That is not what the affidavit says, Your Honor. It says that he's observed present at those transactions, multiple ones.
Present.
Correct, Your Honor.
Present.
And correct, Your Honor.
Yeah, so in other words, so if I live in a neighborhood that's open air drugs, and I certainly have a right to go outdoors at some point, I'm present, right? If I'm close enough to see it, correct?
I don't know if close enough.
Because you said present. I mean, in other words, see words like present, yeah, you are present. If you live there, right? If you live there, you are present. But you didn't say anything about drug trafficking in terms of distribution or possession.
Correct, Your Honor, I didn't, but what I think
So I'm there by association because of or proximity.
No, Your Honor. No, you're there, Your Honor. The way that this is described, and I think the fair inference that the judge can make, given that this is a place that contains mid-level and street-level distribution, and that Mr. Griffin, Desmond Griffin, is identified as a drug dealer in this area, for him to be present throughout multiple transactions that are occurring right there in front of him at that location, and then going in and out of 6740, and that's what the surveillance has shown, is the most recent tie to the court's question to 6740. It's not the only tie,
Okay.
but it is the most recent tie. And that's why we think
right.
that Judge Claggett's finding is entitled to deference there, because it is a reasonable and a substantial basis to find that there could be contraband at 6740 associated with the trafficking that's going on right at its doorstep and constantly. For a number of years, but also a lot even on that August 9th date where Mr. Desmond Griffin was referenced. I want to also, Your Honor, touch on the Leon question. As we look at the idea, and this also addresses, I think, Judge Gregory, your point about sort of the neighborhood dynamic. When the court takes a look at JA 164 and 165, these are overhead aerial views of what this location looks like. It is actually, would be a bit of a stretch to call it a neighborhood. It is small, and the area that they are looking to search is small. First, it's 6740 in the residence itself. But as we look at the reference in JA 151, and that's at B in the search warrant, entering and searching any portions of the dirt driveway that is contained on 6790 Kent Road and or 6738 North Solomon's Island Road. What we are talking about is law enforcement, the affiant, looking at this and saying, it is not clear that the dirt drive where we see a lot of this open air drug market is actually entirely 6740's property. And so, to the extent that this dirt drive touches on property that may be owned by addresses that don't use that drive because they have their own access to the main road, we are also asking the court for permission to search the portion of the driveway that may actually not be on 6740, but may actually technically be the property of 6790 or 6738. It's that kind of care. It's that kind of attention to detail in this that we would argue supports a good faith finding under Leon also. This is narrowly tailored to be 6740, the area that's right in front of it, the area that's right on its side where you can see in J165 and 164, the Chevy Tahoe, and the area that's just in front of it that goes to Solomon's Island Road Route 2. What's important to note also is scale, and we see.
Do you agree that under that warrant? Do you agree that under that warrant you could search any car parked in that area that you just described?
As we look at the area of, and I'll to keep
whatever that area is you just described, you don't have to re-describe it. I think you did a great job describing that, because you do talk about vehicles in the area. That would have to mean that area, right? So any vehicle that's parked there, you could search it.
Correct.
Right?
That's what the warrant authorized, Your Honor.
It wasn't limited by the description of car, license plate number, or being an in-state tag or anything, or any description of the driver or passengers or whatever, that you could go in there. For example, if I just came by there and I just happened to stop, then you could go into my car. Right? Isn't that right?
It's not, there is no limitation.
Is that right? Is that right?
That is right, Your Honor.
Right. So that means that's what I'm saying. And so other people who are in the neighborhood, but you're in that area, you could just search my car for no reason at all, without any criminal suspicion at all. It's kind of a dragnet, right, for that area, isn't it?
For this very, very narrow location where there's trafficking as a drive-up shop, It is,
How many cars do you think could be parked in that area you just described?
ooh, Your Honor.
It'd be hard to imagine. Over 20, wouldn't it be? Over 20? 30?
I think 20 is possible. I think 20 is, I think they would be stacked up, Your Honor, pretty bad up to Route 2 if we did 20, but I think that's possible.
There's a lot of them in it. Yeah, that's pretty broad, isn't it?
Well, I think it's actually the areas where this is where this is occurring is actually a little narrower, Your Honor. As we look at the tree line that sort of blocks the view from Route 2 down there, the area where you actually, because you can't park at the trees, the area that you would actually have room to park there, this is a pretty narrow spot. Remember, as we look at one.
Okay, I accept your 20 cars. I figured it had to be about at least 20 cars. So it doesn't really matter in that warrant at all what the person is. They just stop there. A bill collector stopping there, a person who stopped there because they needed to get something out of my car or whatever, or they're visiting somebody. That's a pretty broad warrant in it for that sense, right? Because we're talking about the vehicle. It's not just that's broad for the vehicle. Why didn't it say someone parked in front? And I think we could understand that in front of that address. But to say that whole area, that's pretty broad, isn't it?
It is broad. It was attempted to be narrowed by the affiant, who obviously didn't include sort of the rest of the driveway. For example, that's another 200 feet past the address, where nonetheless there had been, reference in the affidavit to drug trafficking that could have touched that.
So these facts, as to the car, this doesn't even come close to Leon. Leon is the most stretched case in the history of American jurisprudence. Because if you look at the actual Seminole case, these officers did incredible work in terms of what they did in detail. And now, all you just say is Leon. Just that one word, and all of a sudden that's fine as long as. But no, we have to go back and look at it. That's just, you could have. There's no limitation at all. You wanted to include any car that just came up there in that area that you could just go into, and that's anyway. But anyway, that's what I thought. Just want to ask you that, but it cleared my mind. That's exactly what it was. 20 cars or more, based on your assertion. I accept your estimate, and without any connection with any drugs ever been there before, whether they're licensed or not, whatever would be, you could just go into it, and without any restrictions. You're not even seeing some contraband through the window, so it's not a plain view restriction at all. It's not anything at all. And that would go to going into his car with the gun. But go ahead. You go ahead, finish. I'm finished.
Yes, Your Honor. I would note that, as the court noted, Leon does allow for officers who rely on a warrant issued by a neutral magistrate. They most often act in good faith. And there really isn't a basis to believe that these officers, during obviously the execution, but also in obtaining the warrant, et cetera, that they weren't doing so. And if they did, if this court were to find that they ran afoul of the Fourth Amendment despite their best efforts, and in this case, there's really no basis to believe that suppressing this evidence would produce anything that were just marginal or non-existent benefits. And in this case, we would argue that they are.
It might be benefits to people. Wait a minute. It might be benefits for people who live in those areas that somebody above their pay grade have called their area open drugs, and therefore allows the Constitution to be exercised to a very limited aspect in terms of rights and protection of other neighborhoods. It's very seldom you have crimes in other neighborhoods where you just say, well, any car parked in that area we describe, we can go into. It's more particularized. But here, so because you said that we don't see the benefit, but it might be a benefit if you happen to be somebody, you've lived there and your grandchildren live there and they're still there, that's where you live. So I do see it as a possible benefit. I think that's one of the things. How do you see the quality of life and the importance of other neighborhoods that people may not even go into, but somehow label as drug areas? But go ahead.
This was not a warrant for the neighborhood of Kent Bottom.
You explain that. You explain that that what you call a neighborhood, and because you've limited. But I think the car thing is very important in that to me, because that's where you had no limitation at all. granted the house, well, at least you got an address. And you said Desmond was coming in and out of there, but I heard nothing about it ever coming in and out of several cars at all in the warrant at all. And therefore, in that sense, that it was very broad. If the person was associated with just with that house, then we looked to be in front of within so many feet of, but yeah, 20 cars, you really were trying to find anybody would be swept up in that. So it's not a matter about whether or not somebody's good or bad. People always talk about Leon as if you got to be, no, I'm not saying police officers are good or bad. The question is constitutionality or not. In terms of good faith, in terms of how you draw it. So that means people really believe that, look, I think I need to do this because this helps me in law enforcement. That's not bad, but it might be beyond what the Constitution protects. That's the question. So it's not about maligning anybody. It's about saying, how you call police? No, we're not calling police. They do a great job. We need them. They protect us. But the Constitution protects all of us, too. Go ahead.
Can I ask you about the ACA question?
I do want to.
Oh, sorry. Judge Benjamin, go ahead.
No, you can go ahead. I had a question I wanted to ask about the ACCA and.
Oh, I do too. Judge Benjamin, go ahead. My question is about that.
It's probably the same thing. How do you, on the, I guess it's Erlinger era, it's my understanding the government is concedes that there was an error here, but this argument that is harmless. And then I guess the second part of my question is, how is this different than Cogdill, where in terms of the occasions?
Yes, Your Honor. The occasions are different because of the intervening arrests in this case. That's just one of the factual distinctions. Obviously, also.
Isn't it also a really big difference that was a preserved error case and this is not?
Absolutely. Absolutely. But in terms of so the standard obviously is very different too. But the facts are different. There was in Cogdill, there was scant evidence. Here we have more than scant evidence of what had occurred. And also we have the intervening arrests between each of them. I think as my colleague, Mr. Bornstein, put it in the papers, he put it well when he talked about the plain language of what occasions mean, the common usage of the word occasions, that no one would look at the three occasions separated in the way that they are this way factually, using the phrase or the word occasions, and believe that they could occur on a single occasion. And in fact, if someone heard you colloquially saying that, they would think that individual doesn't understand what the word occasion means.
The question I was going to ask was about the other ACA question. I guess I'll just say that I'm really concerned that had we not issued a supplemental briefing order, we might have made a legally incorrect decision based on a concession that the government inexplicably never took back during a 1 year period. What happened there?
Noted, Your Honor. That was not a best practice. And what happened there was we didn't really have an objection necessarily to the content of what the 28-J letter that the appellant had brought to the court's attention. Likely should have as a best practice, and obviously we're invited to under 28J to have further expounded on that, but we did not.
Like, in light of that, the thing that we said in our brief, we don't think that's true anymore?
Because it was contingent, Your Honor, yes, and it wouldn't have taken much for us just to say that, Your Honor, this was contingent, and we believe that contingency now has kicked in, and we could have done that, Your Honor.
Understood.
I see that I'm well past time unless the court has any further questions for me. I ask that the
Thank you, Mr. Hayden.
Thank you.
Thank you, Mr. Hayden. Mr. Berman, you have some time reserved.
Thank you, Your Honor. Let me return back to the probable cause and good faith questions, because I do think that any good faith has to be limited to whether it was objectively reasonable to believe that there was probable cause shown as the 6740. In fact, the government in its pleadings in the district court, and it's a joint appendix 115, said...
Counsel, let me ask you a question. Does it matter in terms of the probable cause, since we're discussing the gun, that the car that searched where, I guess, with the gun that you're requesting to be suppressed, does it matter that it was right next to the house?
I think it does, Your Honor, because this is sort of what the government said in the district court. They said it would be nonsensical to suppose the warrant allows for search of all the vehicles in the open air drug market, and the 6740 residence, except for the vehicles that are on the curtilage of the 6740 residence. And that's where this vehicle was. It was on the curtilage of the 6740 residence. So they had that. This has to be measured by whether or not there was probable cause for the 6740 residents and whether it was objectively reasonable for them to believe that there was probable cause for the 6740 residents. And for all the reasons we've discussed previously, we submit there was not probable cause and it was not objectively reasonable to believe that there was. Let me turn back, if I could, to Mr. Hagan's comments concerning the August 9th, 2019 events involving Desmond Griffin. You know, beginning at Joint Appendix 47, continuing on to 48, all it talks about is how the remainder of the surveillance on August 9th, there was significant vehicular traffic in and out of Kent Bottom, significant foot traffic coming from multiple residences and areas throughout Kent Bottom. Additionally, multiple people coming and going out of vehicles parked along the road. I mean, that could describe almost any scenario, but it certainly doesn't describe a drug transaction. And there is no drug seizure, no drug arrest, no drugs found. And then they talk about how Desmond Griffin, this is Joint Appendix 48, Desmond Griffin was present at Kent Bottom during several suspected, and again, non-confirmed, CDS transactions and seen walking in and out of the residence of 6740 before and or after the transactions. What transactions? I mean, these are suspected transactions. And I would submit to the court that observing somebody near suspected transactions away from the 6740 residence, and then the fact that at some point during the day he walks in and out of that house, that does nothing to establish probable cause that contraband would be found at 6740 or the vehicles outside of it. I really don't think I need to gild the lily with regard to Judge Gregory's comments regarding not imputing neighborhood guilt to everyone in the neighborhood. You know, you wrote U.S. versus Black, and you wrote your opinion in Curry, and I have nothing to add to that.
Well, can I add to that? Because yeah. I guess I look at this picture, I totally understand when that argument is made in the context of like city blocks. That seems totally, or large apartment complexes or things like that. But I'm actually, we're deciding the case before us. And what I'm looking at here looks like what we might generally call like a compound that is basically, in some sense, a closely, like, even if this driveway is ostensibly a public street, it doesn't seem very public streety to me. Would you respond to that?
Well, I don't really think that affects the Fourth Amendment analysis with regard to the 6740 residents. I mean, if 6750 or if one of the other residences that's referenced in the warrant has drug trafficking there, that I don't think should be imputed to the 6740 residents as a specific piece of property, any more so than drug trafficking in apartment 22 of a building should be imputed to apartment trafficking apartment 21, or that a house that should be, anything at a house should be imputed to the house next door. I just don't think that the distinction between compound or apartment building or urban neighborhood makes any difference to the Fourth Amendment analysis. They still need to show particularized probable cause as to 6740 residents.
Why isn't the big difference between this case and a city block or a large apartment building? Is like one of the things we worry a lot about the city block or large apartment building situation is ensnaring all kinds of unconnected, unrelated, potentially likely, even sometimes completely innocent people, right? That we don't connect that. But, you know, one of the things that this affidavit, I think, does a fairly good job is saying, for purposes of what appears to be a large outdoor drug market that's been going on for years, these are all basically one place for purposes of that. Like, that's what I sort of understand the government's argument to be, which seems quite different from, I mean, I guess it's not in theory impossible that you could have an affidavit saying an entire city block, but it seems like what you would need to do that is I mean, I guess I've never seen an affidavit that actually tries to do that. So what's your response to that?
My response, Your Honor, is that I think even the affidavit itself recognizes that it could not and did not seek to establish probable cause for everything within the compound. It was limited to 6740, it's the Joint Appendix 32, 6740 in paragraph A, and 6790 and 6738 in paragraph B. But implicitly recognizing there are other houses in the neighborhood that are in the compound that are not involved in drug trafficking, and I just think it is a Fourth Amendment matter. It'd certainly be inappropriate to impute probable cause to those houses simply because they're in the same compound. In fact, the police didn't even try to do that. So unless I believe that covers everything that Mr. Hagan raised on the probable cause issue. As to the Erlinger issue, I would simply note that it was the position of the government throughout this case that Mr. Griffin was a mid-level dealer in an ongoing drug operation. That's what their expert, Detective Howard, testified to at Joint Appendix 719, 722, 723. If I could just have a few seconds to finish this thought. That's what Mr. Hagan said in his opening close, that Mr. Griffin used the Monte Carlo vehicle to package drugs and the Tahoe as a stash spot. That's at Joint Appendix 821, 827, 828. And the government said in rebuttal, Mr. Griffin's a mid-level dealer who used the Tahoe as a safe deposit box at Joint Appendix 883, 885. I think the same thing should be applied to their analysis of the 2014, 2015 convictions that get them over the line to 3 for ACCA. It was an ongoing operation, and one reasonable juror could have found reasonable doubt about whether or not Mr. Griffin did that conduct simply as part of one ongoing drug scheme. I would ask the court to reverse on the suppression issue, reverse on the sufficiency issue, and vacate on the ACCA sentence. Thank you.
Thank you. Mr. Berman, I note that you're court appointed. On behalf of the Fourth Circuit, thank you for doing that. We rely on lawyers like yourselves and the work that you do to help us on these cases, and they're much appreciated. Of course, Mr. Hagan, we note your able representation of the United States of America. And with that, we can't come down and greet you, but know that our virtual greeting is just as strong and sincere. Thank you, and be careful in the weather. Take care.
Thank you, Your Honor. Thank you.
With that, Madam Clerk, would you please adjourn the court until tomorrow?
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.